When a person is sentenced to prison in Australia, the court pronounces the sentence itself and also a minimum sentence or parole eligibility date. Depending on their conduct, prisoners may become eligible for release after that minimum sentence. Australia also has a system of interstate transfers for prisoners. So a prisoner sentenced in Victoria might seek a transfer to New South Wales. New South Wales had a piece of legislation which effectively provided that prisoners transferred into New South Wales shall be deemed to be entitled under the remission regulations to any remission of his sentence of imprisonment, for which, up to the time of his transfer to New South Wales, he was eligible in respect of that sentence of imprisonment in the participating state. Bermingham was sentenced in Victoria to 15 years in prison, with a minimum of 12 years. During his first couple of years in prison, he earned remissions to both the head sentence and the minimum sentence, reducing each of them by 405 days. He then transferred to New South Wales. The court was asked what sentence stood against him upon his arrival in New South Wales, and found that the provision only referred to remission of sentence and not to the remission of the minimum term. As a result, the judge reluctantly said that the full minimum term of 12 years remained in place. On appeal, Justice of Appeal Hope wrote the leading judgment, citing an earlier English court case called Wentworth Securities against Jones, to say that in situations like this, the court could imply additional words into the statute to give effect to the true intentions of the Parliament. Justice McHugh agreed, repackaging the rule in Wentworth to say, first, the court must know the mischief with which the Act was dealing. Secondly, the court must be satisfied that by inadvertence, Parliament has overlooked an eventuality which must be dealt with if the purpose of the Act is to be achieved. Thirdly, the court must be able to state with certainty what words Parliament would have used to overcome the omission if its attention had been drawn to the defect. On this basis, the court implied into the legislative provision the words or minimum sentence, and the prisoner had the benefit of the remission he had earned in Victoria. From this case, we learn that on rare occasions words can be implied into the statute to give effect to the intentions of the Parliament.